What is a proviso in California law? I don't know if you've heard the term proviso in describing a provision of a bill or statute, but basically a proviso is language that's used to exempt something from a general statutory declaration and to provide for this something specifically. Some legal commentators believe that provisos are too frequently used in bill drafting and therefore should not be utilized. Now, a reader of a bill or a statute can usually readily find a proviso because it usually begins with a phrase such as provided that or provided however that. Now, some provisos are ambiguous because they may add an additional declaration or even a new idea that may not necessarily be connected with the preceding clause. This case obviously could be problematic in that type of instance. So as a result, some states actually advocate for not using provisos in statutes. And instead, these states believe that a proviso should be used with language that begins with except that, or even the word however. In addition, some states advocate that if there are several conditions or exceptions to be expressed, then those provisos should be placed in a list at the end of the sentence. Now, what's the difference between a proviso and an exception? In general, again, a proviso is a clause that's added to a statute to accept something from that main clause or to limit the main clause's applicability. A proviso operates basically as a condition or a qualification to the main clause. An exception, on the other hand, is used to actually exclude something from the operation of the enactment of a particular item. Now, one state's legislative drafting manual that I reviewed specifies that these provisos give bill drafters a tool basically for sticking, as they called it, afterthoughts onto the end of a sentence. So states like these advocate for avoiding provisos in bill drafting, and instead these states actually advocate for a sentence being split with the proviso into two separate sentences.